Many of us have found ourselves here covering an important court case without full understanding of the best way to proceed. The jargon is flying at you suddenly: accused, witness, Schedule 6 offence, bail application, and many other terms. In order to navigate the court system, it helps to understand the hierarchy of the South African courts.
So the courts are divided predominantly into two areas: jurisdiction, regarding the geographical area in which they can operate, and then also in the type of cases that they can hear. So traditionally, I think let's start from the bottom and work our way up, you have a small claims court, which is predominantly run by commissioners who are supporting traditional small claims when there is a dispute between two individuals, which is of a small nature with regards to monetary value, but obviously it's very important to the individuals to resolve. Those areas are up until 20,000 Rand. A small claims court within the geographical area can hear those sorts of cases. Predominantly no litigation, or no formal litigation, and no lawyers are involved. Two people presenting their side to a commissioner who then decides. We then move to the magistrates court level, and in that court level, which everyone is I think very comfortable with, there is two separate courts, two separate levels of court within the magistrates court. The first is the district courts. Now, these are the first entry point for many South Africans into the court system, and have jurisdiction of provinces. So each province has different magistrates courts, and they operate within that province. And then they also have a monetary value, the type of cases they can hear, up until 200,000 Rand. So any civil case up until 200,000 Rand will be heard in a magistrate's court. For civil cases, they hear what is classically termed as the minor criminal cases. So they would also hear cases not involving murder or rape or anything where there's a serious sentence which can be imposed. It also is a court of first appearance. So when a criminal first appears, or is asked to plead, or has to make that first appearance after being charged, or an accused, not a criminal, it's an accused, that person then appears in the magistrates court in the district court, where they are then, the National Prosecuting Authority will then place the case, and then the decision will be made into which court this case will be heard, where it will be moved to. In the magistrates court, as I indicated, other than the district courts, we also have regional courts. So there's regional courts per province, also provincially, but they have an increased jurisdiction when it comes to criminal cases. The regional court is able to hear matters involving murder and rape, the more serious cases, and have been given the power to also impose a life sentence if that is warranted. The regional courts have also recently been given a civil jurisdiction, which means that they can hear family cases. Those are your divorces, maintenance matters, custody matters, and they have a jurisdiction up until 400,000. In the superior courts, we have the most common, and that is the High Court. South Africa only has one High Court, but it has multiple divisions. So each province has its own division, and in those larger provinces, or provinces where there are high case volumes, there would be two. So there would be a main seat, and then what we refer to as a local seat in a different province. And the thinking behind that is to ensure that people have access within that province to a court within a relatively short distance. This court is headed up by a judge president and judges, and they hear all cases. They have the authority and the jurisdiction to hear all cases, no matter, irrespective of the jurisdiction. But they do take into account the jurisdiction of the magistrates' courts, and would prefer that those courts hear the cases within which they have jurisdiction. So all criminal, all civil cases will then go to the High Court and can be heard within the High Courts. This includes also appeals of those cases. So out of the High Court, we have specialized courts within the superior courts as well. These are courts which are specialized in nature and hear only certain types of matters. So you have the labor and the labor appeal courts, which would hear any matter related to employment or labor, and they have the exclusive jurisdiction to hear those cases. You then also have a land claims court, which is set up to hear land claims cases relating to all land claims, and they have that specific and exclusive jurisdiction. We have an electoral court set up to hear any matters related to elections. We then have a competition appeals court, which hears appeals from the competition tribunal and resolves those competition matters. And those all fall under the superior court in terms of the constitution. Outside of the specialized courts, we then have the two appeal courts and the final courts. The first is the Supreme Court of Appeal in Bloemfontein, which hears appeals from all the high courts. So any case that needs to be appealed and where someone is aggrieved with the outcome of the decision would then launch an application in the Supreme Court of Appeal, where the decision will then be granted, and that is then regarded as an appeal. They only hear appeal or applications for request for revision of a decision, and that's their jurisdiction. They have national jurisdiction. All cases from the High Court then move to the Supreme Court of Appeal. We then have the Constitutional Court, and the Constitutional Court is the apex court within the country. It has the final decision, and it has the authority over all cases within the country, not only just constitutional cases, but now cases of public interest, which means that once the Constitutional Court has rendered a verdict, that's final. I think the final thing to say about the courts is that the higher the court, the more binding their decision is. So the decision of the Constitutional Court will bind all courts below it.
While the Constitutional Court is the apex court in the country, it only sees a fraction of the cases that the High Court and the Magistrates' Court see daily.
So the case loads, as you would expect, the Gauteng courts obviously hear all the cases, or 45% of the cases in the country. So if you think of all the cases that are heard, 45% are heard in Gauteng alone at the High Court, and that same division applies for the Magistrates' Courts as well. The precise number obviously varies and is something which is very difficult to give, but you are looking at a multitude of cases. If you think about the High Court in Gauteng are hearing all criminal cases emanating from Gauteng, all civil cases emanating from Gauteng, including being the financial hub. Everything is here, being the capital being within Gauteng. All administrative cases are therefore then heard in Gauteng. The choice of those cases obviously is given where the incident occurs or where the respondent is located, which means that many state cases are also then heard here in Gauteng.
One of the biggest challenges that journalists currently face is covering court cases with limited access as a result of the COVID-19 pandemic. The SA National Editors Forum is continuously monitoring these challenges and needs your help to understand where journalists are experiencing problems.